The title of the talk is Who Owns the Intertidal Zone? And this has been if you guys at the back could close the doors as people come in, it would be helpful, I think. I just want to try and keep us on time here. So this has been a pretty hot topic lately. We'll talk about some of the issues that have come up recently that have sort of brought this to the forefront. But we're going to start with the public trust doctrine. So this is something that everybody's heard about who's been involved in this discussion. And it's important to start by understanding two key terms in this conversation: private property law and some of the rights that go along with private property, and the public trust doctrine. The public trust doctrine provides a right of coastal access for certain activities. The term is used the way you think of as you would a financial trust, for people who know what those are. The state holds this ownership on behalf of the public for the public's benefit. So that's what we're talking about here. The public are the beneficiaries, and the state is the trustee. So that's what the public trust doctrine means. The public trust doctrine derives from common law, which is part of the law derived from custom and judicial precedent as decided through court decisions. So this is like, based on precedent in historic cases. So private property rights, lawyers talk about property rights as a bundle of sticks, I guess to explain it to the rest of us. Some of those rights include the owner's right to enjoy the property, the right to eject someone who's trespassing, and the right to transfer ownership. When you have an ownership interest in property, you may have all of these rights, or you may only have some of these rights. We'll come back to this later in the presentation. Who has a property interest in the intertidal zone? So the more accurate question is really who has the property interest in the intertidal zone, and the answer to that question is likely to be multiple parties, including the state government as well as possibly town or local governments. It's possibly town or federal governments, the public, and possibly private landowners. So there's a lot of people potentially involved. So who owns the intertidal? It also depends on where you are. In most states, the state owns both submerged and intertidal lands seaward of the Maine high water mark, which are held in public trust for use by all recreational purposes, as well as things like fishing and navigation. So the scenario that we describe here in Maine is really specific to Maine. It doesn't work this way in other states, necessarily, some other states. So is Maine different? In Maine, the intertidal lands can be privately held, and often are, by upland landowners. These landowners can be referred to as riparian landowners, so you've probably heard that term if you've been involved at all in aquaculture leasing discussions or decisions, or literal landowners. The intertidal lands that can be privately held are defined as the lands between mean high water and mean low water. So we're not talking about extreme highs and extreme lows. Or 100 rods seaward of mean high water, where mudflats would extend farther than that. So rods, if anybody recalls, is a very old-fashioned type of measuring distance. And 100 rods, does anybody know how many feet that is?
Only 16.5.
Lewis, you're unbelievable. 1,650 feet. So 100 rods or mean low water, whichever is closer. So that's where the extent of ownership would go to. However, the private ownership of the intertidal land is still subject to certain public rights. In the case of Maine, the public holds an interest like an easement, so it's not an easement, but it's similar to an easement, over those public lands for use in certain purposes, but only certain purposes. So, what are the public trust uses related to Maine's intertidal lands? Everybody's heard this: fishing, fowling, and navigation. Above the mean high water, the public has no right of access. So above mean high water, the private landowner has full rights. Below mean low water, the state owns the submerged lands. And the public has full access subject to state law that allows for private uses such as aquaculture. So that's why in a leasing decision, if it's below mean low water, the local Shellfish Committee doesn't have to be consulted in granting the lease. Let's see, where did I go? Maine used to be a district of Massachusetts, and Maine state law evolved from English common law, colonial ordinances, and Massachusetts common law. In the famous 1989 Moody Beach case, Bell versus Town of Wells, the court held that the colonial ordinances gave Maine landowners fee title to intertidal land subject to a public easement for fishing, fouling, and navigation. So that was the last time this is sort of codified. So what are the uses? There's no specific definition on what the courts have interpreted this to mean over time. Much of the case law related to these terms is over a century old. So there isn't always a lot to go on for determining modern usage, and that's why this is a lot of confusion, a lot of gray area in these discussions. So fishing, fouling, and navigation, courts have generally held that the fishing aspect of this term includes digging or taking shellfish and worms, but does not include things like taking empty shells or sand from the intertidal zone. It covers commercial, recreational, and sustenance fishing. Fouling has been defined predominantly as hunting rather than bird watching. And navigation includes traveling over the intertidal, anchoring, or pulling up a boat on the flats. The doctrine only applies when you're participating in these activities and does not include general recreational activities. So you can't just dig some clams and then hang out through the afternoon in the intertidal and have a party. If you were to say stop and have a lobster bake or throw a frisbee around, you'd be beyond the bounds of your access privileges under the public trust doctrine because you're no longer fishing, fouling, or navigating, you're recreating. Also, the doctrine does not provide any rights of access across private land above mean high water in order to access the intertidal. So everybody in this room, I'm sure, is quite familiar with that. We'll get to this more later as it applies to the issues in Acadia National Park recently, but the access right is only from the seaward side. So essentially what that means is if you come by boat into the intertidal, they couldn't necessarily stop you, but if you tried to cross their land, the upland to go onto the intertidal, they could definitely stop you. Finally, there have been a number of legal challenges since the Moody Beach case, including one as recently in 2014 to address the Goose Rocks Beach in Kennebunk. That was in the news quite a lot. People probably remember that. And a 2011 decision which held that a scuba diver could cross wet sand to access Passamaquoddy Bay under the right of navigation. So how do you know who owns the intertidal land on a given parcel? Check the town's registry of deeds. Well, that's easy. If the deed is silent, which I think frequently they are, the landowner has presumptive ownership to the mean low water in Maine. So that means if the deed doesn't say, it's assumed that they do own mean low water. Often the deed specifies that the ownership extends to mean low water or only to mean high water. So what about seaweed? Well, there's currently litigation pending that may address this issue. There's an active court case going on. The Maine Attorney General's position at this time, it is unknown whether harvesting seaweed attached to rocks in the intertidal zone is protected under the public trust doctrine. So the position right now is that we don't know whether this is protected under the public trust doctrine or not. Common law is unclear whether seaweed is owned by the public or owned by the upland property owner. Given this, the Department of Marine Resources does not take a position on whether the public may harvest seaweed from those areas without interfering with the private property rights of the upland owner, or whether the upland property owner may prohibit the public harvest of seaweed in those areas. So what's the deal with Acadia National Park? Many of you have heard about this over the last year. Department of Marine Resources has had a number of conversations with the Acadia Park National Park Service staff, and a lot of people in this room have been involved in those conversations. So what about the public trust document as it applies to the situation with Acadia? The Park Service position is that the federal government has preemptive power under the Constitution over state law. Just dramatic pause, I'm trying one of Brian's techniques. So the federal regulations prohibiting commercial harvest within the park boundaries can preempt state public trust rights in the intertidal zone wherever the federal government owns to mean low water. So we don't agree with that. That's the next statement Meredith wrote for me. DMR disagrees. Our position is that the federal government purchases or receives these parcels of land from other landowners. And those landowners did not have the right to exclude people from accessing the intertidal zone. Therefore, this is one of the sticks, the quote sticks in the bundle of rights sticks that can't be transferred when the ownership of the parcel transfers from the private owner to the federal government. So, I mean, trying to rephrase it, it means that the people who gave this land to the federal government didn't have the right to disallow access, so they can't transfer that right to the federal government. The federal government should not have any rights that another private landowner who transferred the parcel to the federal government would not have had. The inverse, of course, is that they should have the same rights as another private landowner. So they're certainly able to exclude harvesters from crossing park lands to access the intertidal, either on their way to or from the flats. So the next steps, we're continuing, we as the Department of Marine Resources are continuing to work with Acadia to resolve this issue in a number of ways. First, we've appreciated that the National Park Service has stopped enforcement of this prohibition while they've looked at their deeds to see whether they do in fact own to mean low water. Initially, when these conversations started, we were told that starting January 1st, 2017, the National Park Service would start enforcing their authority over the intertidal and make everybody stop commercial harvesting. So they've delayed that while they research their deeds. Also, we've had a number of productive conversations with the National Park Service about the health of various resources in the park, and the park is engaged with DMR and many harvesters in conversations about resource management within the park more broadly. We've also been engaged in discussions with the congressional delegation about ways to resolve this issue with a statutory change at the federal level. And several members, like I said, of this audience have also been involved in that process as well. And there is a bill currently in Congress, jointly sponsored by Poliquin and King, I believe, that will move forward to try and address this issue specifically with Acadia National Park. So we do want to mention and acknowledge that we know there's also an issue with commercial harvest at Moosehorn National Wildlife Refuge, but there are separate rules, of course, that govern national wildlife refuges and different regulations for commercial fishing in those areas. So far, we have not spent a lot of time investigating these particular issues, but we would like to hear feedback from harvesters if they're being restricted from these areas as well. One thing that I would like to ask in this presentation is if people are being asked to leave intertidal lands on federal property, that they let the Department of Marine Resources know that they've been asked to either dump catch or leave the area so that we can try and address these issues. And that's it. I can try and answer a question or two if anybody has them. Yep.
This is the 1643 Act that we adopted in Massachusetts. Am I correct on that?
The King's Grant of common law, yep.
500
Yep.
rods past the high water mark down to the low water mark?
100.
100
Yep.
rods. Okay. Why, instead of the adoption, since Maine is our own state, why can't we change the laws so that it works for the harvesters and for the people who work in the state?
Well, I think that's just the history of how the law came to be. I don't know how we would go about changing. That's a question that I'm not able to answer.
It's still an adoption. Why not? We became a state in 1820, so.
I assume it's part of our Constitution, but I don't know.
Thank you.
Is there another question here now?
Yeah, if DMR's position, generally speaking, is that the federal government doesn't have the right to exclude in that intertidal zone, does this federal legislation that's pending, does that set a precedent, basically, sort of, to me, in a way that's almost saying to the federal government, yeah, we agree that you have the right to control that intertidal zone, and we're going to carve out a special exception for Acadia, but doesn't that then leave open, you've got to deal with it on all federal?
So I think that there are only 2 states that still have the common law on the books, Massachusetts and Maine. So they're using it as a really unique circumstance to say this really only applies here because we are a common law historic state. They were very cognizant of that and very careful about it because, the first argument was, well, we don't want to open logging in Yellowstone. They don't want to start allowing commercial uses of other national parks. But there's a lot of nuances to this whole argument that, that I think each park also has its own section of law. And so they're able to address this with just Acadia and it won't necessarily apply to anybody else.
Yeah. And just also, I was on a call with King and Poliquin staffers. They're trying to restrict the language from marine organism to exclude essentially seaweed harvesting. And both King and Kohl are trying, just as a FYI to all these folks, they're trying to keep that marine organism language in there so that the statute stays as broad as possible, which I think is what we want for the future, because who knows, right? So with a mind to that, just reaching out to your local, writing to King and Kohl and saying, we really want to have language to state marine organism wouldn't be a bad idea. That's essentially what they said to us. They said the more sort of, they're getting a ton of heat to restrict it. So they need the other side to be able to pull it through.
So I do know the Shellfish Advisory Council participated also in these conversations and had some activity around writing letters. We provided some contact information, and we could do that again, or people can find their representatives or senators online, but that's a good comment. Yeah.
Kohl, do you know if anybody's looked at the Coastal Zone Management Act and whether the federal consistency element of that relates to this?
I don't know.
Because that is supposed to keep the feds from asking for more than they should from the states in the coastal zone.
I mean, I would assume this is because they have, these are lands they own. Why that would be different than, getting a permit for dredging or something like that on lands that they don't really own by deed. But I assume Meredith has looked into that because she's, pretty close with that program as well. So I'm gonna, Louis, do you have one more thing to add?
Well, just the other important part of this is that the tax was not only looking at property that they own, but also property that they had interest in, that land trusting was giving them authority on. So it could be a lot more far-reaching. It's not just Kohl and King that's working on this as well. Susan Collins is quite active and involved in this as well, because that's been one of my primary contacts as chair of the Shellfish Advisory Council as well. So all three of them need to be spoken to frequently by us.
Yep.